Good afternoon. Everybody, go ahead and finish digesting your lunch. My name is Ken Hirsch. I'm Director of Computing Services at the Duke University School of Law, and the title Senior Lecturing Fellow means that I occasionally teach as well, or at least attempt to teach. With me today up here are Wayne Miller, our Director of Educational Technologies, Brian Donnelly, Director of Educational Technology and Lecturer in Law at Columbia Law School, and Bob Seibel, who's Professor of Law at the City University of New York School of Law. And we are glad you're here, and you see on the slide, and of course you've already seen in the agenda for the conference, that the name of our presentation is it time for legal technology curriculum? That's not a rhetorical question, and as far as the four of us are concerned, we already know the answer for ourselves, and that is yes. And the answer is what we hope to impart today, at least what I hope to impart today, is that most of you will come away agreeing with us and will take that belief back to your institution and do what you can to proselytize on behalf of that answer. As primarily a legal technologist, I want to give you my point of view. So it says a law school technology view of a few, and I underscore the word few, key dates in American legal education to set the context for what we're talking about today. And we're all aware of some of these. In 1779, George Wythe teaches at the College of William and Mary, becoming, for all intents and purposes, the first permanent law college in the United States. In 1870, Langdell introduces the famous Socratic case method at Harvard. In 1961, the clinic movement begins in earnest. In 1969, now 35 years old, the Internet was created, though, of course, for about 25 years it was known to a relative few people, primarily in academia and in government. In 1980, the IBM PC is introduced, which begins bringing PC computing power to the masses. In 1982, our sponsor, the Computer-Assisted Legal Instruction, was founded. Why that says education, I don't know when that happened. In 1993, now 11 years ago, the killer app of the Internet, the World Wide Web, gets public. Now, in a world dependent on information technology, and to cite some examples, law firms build extranets to communicate with clients. More and more courts require electronic filing for both efficiency, for making documents available to parties more quickly, to cut down on person hours required in handling paperwork. Knowledge management organizes institutional memory so firms can easily determine whether they have conflicts among clients and potential clients. Online legal research is efficient and, in relative terms, economical. Sure, when you leave law school, it's not free to your students, but if they use it well, then when you balance the value of a lawyer's time versus the payment to Lexis or Westlaw, in general, you can do it on an economic basis, economically justifiable basis. And evidence, as we'll see even by example here, probably in a few minutes, is presented digitally. And where law schools depend on information technology because our prospective students nearly universally fill out their applications online, in most law schools, or at least in many law schools, and certainly in the ones that I've seen reporting on the TechNoise list, 95% plus bring a notebook computer, even where notebook computers are not required by any formal requirement. And email, no doubt, is the predominant means of one-to-one communication, and websites are the predominant means of mass communication. Yet, and Ethernet and wireless are virtually pervasive, as demonstrated amply here. And schools are now, we have outside, competitors in this market, the exam administration software market. Schools see the utility of that. Many schools spend literally tens of thousands of dollars a year on that one product alone. Yet despite all that, most law schools give little thought to the integrated use of information technology once their students get their diploma and walk out the door. Many faculty still resist the use of technology in the classroom, even though the environment is there and it would benefit their students often, certainly not always, but often would benefit their students if they would integrate technology to some degree. And all of this going on at law schools is lagging behind despite the McCrae Committee report, which is now 12 years old, which was highly critical of the skill sets that law students come out of law school with, and among its fundamental skills listed. In order to practice effectively, a lawyer should be familiar with the skills and concepts for management, including developing systems and procedures to ensure that time, effort, and resources are allocated efficiently. And I'll jump down to the bottom, developing systems and procedures for efficiently administering a law office. Now, if that doesn't cry out for technology, I'm not sure what does. In response, some schools have developed or expanded skills courses and clinics, and they're to be commended, but I would argue not nearly enough have. And some schools have added courses which look at part of the role of technology, but I would put it to you, few are looking at the integrated role of technology as a whole, the whole breadth of practice area and what students do. Having set the context, I'm going to turn over the next few minutes to Wayne Miller.
Okay, I'm going to talk a little bit about what's going on at law schools. We were very curious to see when we started this, looking into this as a systemic issue for legal education. We were interested in seeing what was going on in law schools. I found this quote. I found it very interesting. Technology will be important, but legal education will not be the engine. It will be the caboose. Now, if you are a train aficionado, you know that cabooses are all like this now. Trains do not travel with cabooses anymore in this country. So that struck me as an apt image for looking at whether law schools are perceiving this change appropriately. I wanted to get an overview. Why not emphasize technology? Well, some of the reasons we came up with and heard others say were, well, it's not thinking like a lawyer. That's what law schools teach, thinking like a lawyer. It's just a skill. Skills can be learned anywhere. Non-lawyers can take care of that. Don't waste the expensive lawyer's time. And you can't know what technologies are coming, so why even bother? And ultimately, the point is, it's just a tool. Well, my counter-argument, and this is my formulation of it, is, and certainly many of you will have your own, it's a meta-tool. It's not simply a tool that you apply and forget about. It's a fundamentally different way of doing the same old thing. And by being fundamentally different, it introduces new complexity. If you're familiar with complexity theory, what we're talking about here is emergent order. Brand new things come out of the same inputs with a different, with this iterative function. And, well, how can you make that seem more real? If you look at the way we now understand static images, the rise of the photograph, and then the photographs were put together and streamed. And that created a whole new way of seeing the world through what we know as most generally as movie, but which has come down to us in many different technologies, televisions, videos, video games, animation, virtual reality. The second thing is it's a tool whose conventions you have to get. It's something that takes exposure, and we all know this. It's the way the software is designed. It's designed to follow certain conventions. Interfaces keep replicating themselves across different software applications, and it takes just exposure. And simply there are implications to using technology for legal professionals that require an understanding. You can't just listen to a tech person and say, well, isn't that like a garbage disposal? And really understand the situation. Anyway, so what we did is we followed through with 2 surveys. Many of you will know this survey. We sent it out on Technoids and said, let us know what you're doing in your, at your law school. And then I went through and looked at every website for every law school to see what I could find online in their self-representation of how technology is taught. Okay, what did I see? There were a lot more courses than I thought there would be, broadly defined, and I emphasize broadly defined. I didn't set a very high standard. There were very few examples of widespread institutional commitment. There were a few, and I don't highlight them here. And there was very little sense of a coherent standard practice. Now, the respondent survey, there were 51 responses. The most frequently taught aspects, and we came up with these categories a priori. You'll see why I think it's unfortunate we did so. Legal practice management was the most common one. Courtroom presentations, standard office software, information literacy, and then litigation support. I'll come back a little bit to that. We also did the website survey. And as I said, I went through all 187 ABA, at that time, I think, ABA accredited law schools. There were a wide variety of detail and orientation, but patterns emerged. Here I came up with different categories, and that's why I felt, ooh, that wasn't the best thing. But literally, to distill course descriptions into buckets, this is the best I could do. There were some other buckets, but these were by far the most common: law practice, trial practice, computers, and law. Now, there are a lot more of each of these courses. These were courses that were attested to as having a technology component. So how do these map? Well, it didn't map very well, but I think you get the idea. It kind of, they're the same things. They're just phrased differently. So here's an example of, say, a law practice management course. There's the description, and here was a key sentence. I've highlighted technology just so it was easy to pick out. Here's another interesting example. Technologies presenting interesting and new legal questions. And it goes on from there. Here's William and Mary, a trial advocacy course, emphasizing here presentation. And here's a computers in the law course. There were many of them that were about technology's impact on clients, how it changes the client world. Relatively few, this number you saw, that said, how is this also changing the law and the legal system? All right. I think this is where Kim comes back.
So our goal, and by our, in this case, I mean Wayne's and my goal at Duke, is to develop a course, a comprehensive survey course, and we emphasize a survey course because there's no way that, in our opinion, one course could teach a law student every possible thing he or she needs to know about what it takes to practice as a smart, skilled lawyer in the outside world with technology. It would be taught by ourselves as well as other faculty and guest lecturers, including interdisciplinary people. And the rationale is this, that curricula do not integrally reflect the ways in which information technologies are being used and could be used to change the practice of law in the United States. So that while law schools have embraced online publication databases, many other transformations, legal best practices remain outside the scope of today's law school, and we need to have much more. Now, if I hit one more, is it going to say end of show? I don't remember. So we've got a course proposal, full semester course, 2 credits, pass or fail, and this is just a quick listing of what it would include. And there's a draft syllabus, which I will not show you, thank goodness. And some of the important things we think that are very significant to be covered would include client communications, trial practice. But again, trial practice is in many, if not most, law schools. The technology used in trial practice itself is largely covered in the practice courtroom setting. So that would be a smaller part of our course. Again, we're doing a survey course. The Internet beyond legal research. So there are many uses for a practicing lawyer to do the Internet beyond trying to find some way to outthink Westlaw and Lexis. And information literacy in general, figuring out what's authoritative, what should I be paying attention to in a world where there are thousands of sources of information? And finally, why must law schools integrate this into the community? Because the ways in which technology will change the practice of law are as fundamental as any of that the profession has faced and cannot be assumed away from the curriculum as matters for non-lawyers and technology specialists. Thinking like a lawyer is no longer enough. A lawyer must also think like an information handler in an information age. And then we turn it over to Brian.
See if I can get this lav to work. I think I can get it to work, right? I think it's on. It's on. Okay. Well, I'm Brian Donnelly, Director of Education Technology and Lecturer in Law. And one of the things I do at Columbia is worry about things like lavalier microphones and classroom technology. The other thing that we do is support the course webs and using web to help out the curriculum and sort of generally trying to get technology into the curriculum to the extent that faculty want to do that. And one of the things we've been able to accomplish is to create the Lawyering in the Digital Age Clinic. And I suppose you might ask, well, what the heck is the Lawyering in the Digital Age Clinic? It's a little difficult to say in, say, 2 sentences, but I'll give it a try. One is that it's not cyber law, right? It isn't, typical cyber law course. And I guess, probably the best thing I could do in 1 sentence is to say that it's a clinic that focuses on the integration of technology with lawyering skills and through student fieldwork projects supports a wide range of public interest organizations. So that's probably the best definition of it I could give you. And maybe a little background might be helpful as well. The clinic evolved actually from a previous clinic, the Fair Housing Clinic. And in 1995, if you folks who were around back then remember folio views, right, where Lexis came out and gave everybody folio views. And we thought this was pretty interesting. And I started a collaboration with Conrad Johnson and Mary Zulak, who are both longtime clinical faculty teaching this Fair Housing Clinic. And so we put about 700 pages of statutes, federal and state cases, federal and state regulations, secondary sources, and that kind of thing into electronic formats as teaching material, which I imagine a lot of people did. And we saw, well, gee, as students go and do their fact-finding assignments, well, they could put those into electronic formats as well. And so we collected those and had students stay in the electronic formats there. So as they prepared for their interviews with their fact-finding, they were also using the fact-finding materials in their interviews, and as they were conducting their interviews, they had their laptops and they were staying in electronic formats there as well. And so sort of the next phase of the clinic, typically is this case planning phase where students would take the information that they gathered during the fact-finding and their interviewing, and they would connect up the law, the statutes and cases, regulations, and that kind of thing, in the case planning. We're doing all this hypertext, along with annotations and all the other cool stuff that Folio would allow you to do. And so once we got through the case planning stage, well, then students would start drafting. And when they were drafting, of course, well, they could take all the other stuff that we put together in electronic formats, and they could use that and hypertext back to a specific provision within a statute or regulation, that kind of thing, and put together a pleading that actually included all this previous work that they had done before. And also, the Fair Housing Clinic had its own docket. There were folks who were involved in housing discrimination cases in federal courts and state agencies and state courts, and so we were keeping track of the cases that we were doing in electronic formats. And it struck us that as I was getting more involved in the clinic and trying to help students understand how to use the tools to make these kinds of things happen, that what was happening was that technology was sort of growing to be a bigger and bigger part of this conventional clinic, and that it was becoming difficult to do both, teach them about the technology as well as the substantive area of housing discrimination. So we developed a new curriculum in 2000, right? And when you figure that the period between 1995 and 2000 was really, pretty revolutionary, right? The developments on the web, and computers generally. And so, during that period, it just became more and more obvious to us that, the world was changing, right? That we really needed to help prepare students for the environment they were going to be practicing in, after the year 2000, not, the way it had been the last X number of decades. So we put together this curriculum where, we would put technology at the center, just in the ways that Ken and Wayne have been talking about, right? Just for the same reasons. And the other thing that we would do is take the students' enthusiasm for the, computer technology that they sort of come to law school with, help them sort of focus it in a way that would help their different public interest organizations. So after sort of experiencing this for several years, we came up with a couple of basic ideas, right? One is that all lawyering tasks involve an information component. And that if you break that down, basically all lawyering can be put into these three boxes. I challenge anyone, to think of a way in which, what it is that lawyers do doesn't fit into these three boxes. So that's a place to start, right, for coming up with a new curriculum. And we were going to teach the traditional skills, right, about interviewing, case planning, and drafting, that kind of thing, and fit them into this paradigm. But we would also do it, sort of expanding upon this, right, so that we would be very deliberate in the way that we would teach electronic fact gathering, very deliberate in the way in which we would teach knowledge management theory, try to get into courtroom technology, web development, using relief in alternative formats that you can now do using information technology. And so, we have the classroom component. It's a 5-credit clinic, and we meet for 3 hours at a time, twice a week. It's quite a bit of sort of technical background that we can give students, but then we send them out into the field. And we've sent them now into a wide variety of organizations. Both Conrad and Mary had, in previous lives, been the attorney in charge at the Harlem Legal Aid Office, and so their knowledge of how one of these offices works was pretty deep. And just sort of through connections in the community, we were able to come up with lots of other projects for students to work on. And so I think one of the more unique aspects of the clinic is that we're going out into the field and trying to help students work with attorneys. And students are able to help attorneys sort of on a one-to-one basis. A lot has happened just in sort of the student sitting down with the practicing attorney and showing them, just some basic computer skills that has actually made a pretty big difference in the way in which these lawyers practice. And then we've also worked sort of on the organizational level as well. Obviously all of this, let's see if I can get this to happen here, happens, using websites and, web-based material now, right? This is what we call ClinicNet. This is a site where we work, in sort of as an extranet with the different organizations that we work with, and students post their work onto this website. It's able to be managed in such a way so that we only have the people getting into the different areas that that are relevant to them. And so we try to take what we began with, just using things in electronic formats, to this very web-based, web-centric, and almost completely electronic way of both looking at studying the law and then the way it's practiced. So that's basically where we're at with that. And then Bob's going to talk about what he's doing at CUNY in his clinic.
Actually, I'm really not going to talk about what I'm doing at CUNY. And I'm not going to use too much technology. Before I get into the substance of this, there's no final plenary at this conference, and I just wanted to take a second to thank John Mayer and Deb Quentel and CALI and all of the sponsors and the University of Washington for allowing this conference to happen. I hope you had the same experience I had. It's been great. And the University of Washington tech people who have helped us maneuver and navigate through all this equipment have also been just fabulous. So I wanted to acknowledge that.